points on Fresh 106.9 FM. Now, the topic we have for discussion, the earlier topic, which this also makes the concluding series of that topic of that series, Judiciary as the last hope for the common man. And we have in the studio this morning, for a second time running, Dr. Michael Afolayan, a legal practitioner, notary public and head of Department Business and Industrial Law of the Department of the Business and Industrial Law Department of the State University. I'd like to thank you very much for coming on the program this morning.
Thank you very much. Good morning, Mr. Bamidele. Good morning, listeners at home, at work, wherever you may be.
It's good to have you here for the concluding part of this series. Like we had a lot of callers on the last edition of the program.
Yes.
We talked about highlighted the judiciary as the last of the common man. Infringement of rights infringement, people doing their laws, and there were so many questions people wanted to ask, but then we couldn't get to conclude that series. But glad to have you back on today's edition. Now, a recap of what we did, what we had discussed on the last edition about people knowing their rights and the judiciary as the last hope of the common man.
Yes.
Well, but then we also ended at the point that where people do not even know their laws and how well we could also educate people on knowing these laws and to know when their rights have been infringed.
Definitely. Yeah, you say I believe what we extracted on Monday, which had to do with the performance of the judiciary so far in Nigeria today. I believe there are many aspects to it, and I have said that the judiciary is expected to, operate against the backdrop of the power that is their power that is enshrined in the Constitution, and to whom so much is given, much is also expected. And judiciary being a very important arm that oversees resolution of disputes, interpretation of the law, especially the Constitution, it is very, very vital that people know, what this arm is about, that they, arm themselves ahead of, the challenges that may crop up from their daily activities. And we also mentioned the importance of, at least having a lawyer around you, or at least knowing basic laws, which, will empower you to be able to, place yourself properly in whatever transactions you are in or relationship that you are in. It is very important.
I know some of these rights, like we highlighted also that the judiciary being the hope of the common man, we're able to look at, we were not able to x-ray the democratic process also, and how the judiciary has been able to fare in the last couple of years that we've had democracy.
Yes.
So moving forward now, we look at the democratic process, the issues of electioneering and elections itself. The issues having to do with the contentious issues with them running for government office and also getting that ticket, the processes, and also being elected into political office. When we look at that democratic process, have we been able to use the law to ensure that the right people get voted for during primaries, the right people are on the ballot boxes, the right people also get elected into the offices, and also as the judiciary being able to maintain that the right people who win the elections, the votes are validly counted, and we have the right people in the saddle?
Yes, thank you very much for that question. We said the other time that people are readily willing to let their right go, especially when it is infringed upon. Number one, because of the cost of litigation, access to justice and all of that. But one area where people have not been letting go, in this country, is when it comes to election. Don't forget that politics in Nigeria, as it's also obtainable elsewhere, is a high-stake game, because it has to do with, I think it was Harold Laswell that said, politics is determining who gets what, when, and how. And so the question of who is going to occupy a particular office is always paramount when it comes to politics. And so, and the only way, especially as stipulated in our Constitution, to occupy these offices is through election. Getting to the seat of power by the gun is old-fashioned now all over the world. And so it is election, as stipulated by the Constitution. And you discover that the electioneering process is always fraught with irregularities because of the stakes that are very high, and because the players are ready to do anything to get to the seat of power. So they violate every rule that guides the game, right from the stage of primaries to the main election, you see infractions here and there, blatant and flagrant infractions of the applicable laws. So eventually you discover that most of our elections, they are not, in fact, elections in Nigeria these days, they are not complete until the court has pronounced on them, which is not always the case in other climes. We have climes around where people hardly go to the court after elections. But because here, number one, people are bad losers. Number two, people are desperate to occupy positions. Number three, everybody is violating the law. Both the opposition and the main political party, you see them violating these laws right from the process of selecting candidates. So that leaves a very large chunk of the decision of who occupies political office in the hands of the judiciary. So most of the time, you discover that it is the courts that will thereafter install, from their pronouncement or as to the process, who is going to occupy office. So if we want to assess the performance of the judiciary in terms of our election in Nigeria, in the years past till now, I would say that the judiciary has weathered the storm. We have had so many landmark decisions from the judiciary. If you have not forgotten, Rotimi Amechi in Rivers State, the election that brought him in as the governor, it was the court that put him there as a governor, even though during the election, from the primary, he was even excluded in the first place. And the court said his exclusion was unlawful, and that whoever was used to replace him was there illegally, and as such a person could not hold that office. And so he was declared as a winner, even though he was not the one on the ballot for the election. And so this is one of the very key areas where the judiciary has really interpreted the law to bring about a very radical outcome, which shocked everybody. And from that time, even before that time, and since after that time, we've had so many other radical decisions like that, which have prompted the legislature to want to look again at the rules, amend them in order to avoid some unpalatable outcome that the court may have to decide thereafter. But I would say that the judiciary has really tried the best, but that is not to say that the judiciary has been perfect when it comes to our electioneering and democratic process, especially in their duty to make pronouncements as to law and the electioneering processes, because we've had situations where there have been allegations of compromising judges or judicial officers in order to make pronouncements one way or the other. We've had politicians who go to court to obtain injunctions, injunctions that leave so much to be desired from the process, and then we have up and downs, anyway. But I would say, all in all, the judiciary has been trying its best, and on a scale of 1 to 10 again, I will give them 6, 10 being the highest.
So that when we look at our democracy now, and up to where we are at the moment, we see a lot of litigations that have to do with court processes. Sometimes you see one court, we see a situation where after the high court, we have litigations at the high court, we see the defendants take it again to the appeal court, only for us to get to the appeal court and it's also suspended. Before you know, we have to go back again to the Supreme Court. So we have situations where the appeal court is the high court is giving one judgment, the appeal court upturns it, only for us to get to the Supreme Court, which upholds the judgment again. And we see courts clashing at different stages. Would you say that it's a result of a superiority race between these courts, or do you think that sometimes the law itself needs clarification onto itself?
No, I would not say that it's a superiority race. Like I said earlier, the stakes are high whenever it comes to politics and elections in Nigeria. I think what happened is that people have been latching on some of the loopholes in the procedural laws in order to cause upheavals. Don't forget that these people they will do anything to get to power. And when it comes to our own legal system in Nigeria, we have what is called appellate system. Like I said earlier, the judges are humans, and it is believed that when it comes to interpretation of the law, a court should not be a lord unto himself, or the final court unto himself. And that is why in our appellate system, when decisions are given, for example, by an election tribunal or a high court, such a matter can still be, pursued on appeal to the Court of Appeal, and there are instances where such a matter can go as well up to the Supreme Court. And we have instances where decisions that are given by the High Court may be upturned. Of course, the Court of Appeal has the right to upturn it if they discover that probably the High Court has erred in applying the correct law, or probably in not evaluating the fact properly enough. So the Court of Appeal, being senior, in rank, in hierarchy to the High Court, can upturn the decision of the High Court. And if the matter goes ultimately to the Supreme Court, the Supreme Court justices also have, a higher power than that of the Court of Appeal, and they may also decide otherwise. They may go with the High Court, or they may go with the Court of Appeal. It depends on, the fact of the matter that is before them. It has always been the procedure, even elsewhere. There is no issue about that. But you see, the politicians, and maybe I will say some of other players in the judiciary, line, for example, lawyers who help them to file these cases, at times may be mischievous. A matter that has been determined in a particular high court, you see it being litigated, that same subject matter being litigated upon, in another state. You may even take it to the Federal High Court of another state, and you see such a matter coming up there again, and then at the end of the day, you find conflicting decisions, on the same subject matter coming. And I think what the judiciary really need to do is to be wary, especially when, matters of political interest or political matter comes before such courts. They should look around, they should observe and see whether, some of this, a matter on that same subject matter is not being litigated upon in another court, so as to now make the judiciary, look like a fool, especially when you have 2-3 conflicting decisions. And whenever such a thing happens, it is not good for the system. And in some recent cases where we have such a thing, you see the Chief Justice of Nigeria summoning such judges for disciplinary action, or querying them as to, the propriety of what they have done, which is not good enough. So I believe these are part of the downs of the judiciary, which really need to be looked into in order to have a safer and more predictable system when it comes to adjudicating on electioneering process in Nigeria.
We've seen instances where the judiciary has been accused of reinstating more people who have lost, upturns many decisions, or many elections that have been won at the ballot.
Yes.
We've seen instances where it has to be the court that upturns these decisions and restates sometimes not too popular candidates in many elections.
Yes.
In recent times.
Yes.
So does this also put some question on the I'm looking for a word now. Does this put question on the credibility of the judiciary?
Well, I will not look at it that way. You see, the business of the court is different from the politicians. Don't forget that in election, they are looking for highest number. When the matter goes to court, what the court is looking at is the laws, whether there is compliance with the law. It doesn't matter whether the majority, maybe even over 90%, are on the wrong side of the law. The court will declare it invalid, irrespective of the fact that they are on the majority, if they have violated the law. For example, we've had cases where, I think it was in which state, where somebody was fielded, I think was Bayelsa, where somebody who was not qualified was fielded as the deputy governor. Candidate. I think it was in APC or so. And so, eventually, when the matter went to court, the joint ticket of both the governor and the deputy governor was nullified. I think it was Leon.
Yeah, Leon. Yeah.
Yes, yes, he was even planning. He was already preparing to be sworn in. It was at the point he was preparing for swearing in that, and he had no problem. It was the ticket of his deputy that has the issue, and their joint ticket were together, so it was nullified. And the present governor was put there instead, because in the process of fielding the candidate, the political party that they belonged made that very fundamental error, by not complying with the law, and so that affected them seriously. So the court at that point is not looking at whether he was elected by the majority or not. The court was looking at compliance with the law. And I think this is where I've always said it, that our political party should also help the system, rather than throwing up log jams that will eventually lead to the court having to do whatever it has to do to put somebody there. They should get it right from the beginning. Yes, because if you look at our electioneering process, especially when it comes to party primaries, picking candidates and all that, you discover that a lot of infractions usually have happened at that level, because we have godfathers within the system who want their own anointed godson son to be there. And so in the process, they don't mind violating any of the process. They will say, we'll meet in the court because we believe we have the system. So as such instances, the court will have to do whatever is needful. So the interests are very, very different. Yes, of course. So the court is right.
We've seen the judiciary wade into a lot of matters having to do with chieftaincy, tussles, land delineation, and all that. We've seen some cases that have stretched on into years.
Yes.
As much as 3, 4, 5 years over issues that has to do with chieftaincy, tussle or delineation of area, but so sometimes people have raised them concerns about the length of
time.
the time of getting justice served at the courts. I think there was a former Chief Justice who said that he was going to ensure that we have timely judgments at the court process. But when we look at this time, especially land tussles and all that, why do they take so much length of time?
Well, you see, our system is evolving. When you look at I think majorly the issue we have is our procedural laws. And I want to, give kudos to the judiciary in this light, because from time to time you will see that our rules are being overhauled. Those who are not in the system may not really understand. But you see, when the procedural rule allows for parties to waste time, of course they will waste the time of court. For example, in the case of Ariori and Elemo, it was in court for more than 20 years. It wasn't more than 20. It wasn't the generation that started the case that finished it. You have substitution of the son for the father who died along the case. But all those years were years when you can just go to court, file a writ of summon, and just the writ of summon alone, and go away and go and sleep again until any time you waste the time of court, and then you come back again, you file your statement of claim, you go away again, and you see a lot of time being wasted on such matters. But over the years, for example, in 2004, Lagos was the first to take the step to overhaul the civil procedural law by bringing about the front-loading system. So today, when you want to file a matter in court, you are expected to file all your papers alongside with the list of the witnesses that you intend to call, rather than the previous system where you have to waste time 2, 3, 4, 5 years. You are still at the preliminary stage. But today, as you are filing your originating paper, you are expected to file all the papers, including the papers, the documents you want to rely on as evidence, or that you may want to tender in court as evidence. All of those things are expected to be filed, front-loaded now. So when the other party is being served, he already has all the totality of the case you have against him. So he is also expected to file everything front-load. So today now it is possible, because once the party that is originating the case files, in Ekiti State, for example, the other party has 42 days to reply. So you discover that these days we have matters being dispensed within 3 months, 4 months. Matters don't last a year, 2, 3 years like before, except where parties are the one delaying themselves. Probably when it is time for them to call their witnesses, they are not coming up, and we have instances where the court will strike out the matter for wasting the precious time of court. So I believe things are improving. Even in criminal matters, we are having procedural rules that says you cannot take more than 2 adjournments when a matter is before the court. Once you take the first adjournment and you take the second, it means you have wasted all the time you have to ask the court that it should adjourn because of one reason or the other. So other ones, you see that matters being dispensed with the more quicker way these days than before.
Okay, access to justice is another. I'm sure listeners out there want to know access to justice, quick access to justice.
Yeah.
And a lot of like I said, I highlighted before we started the program. a lot of people believe that when you want to hide things from Africans, the easiest way is to put it in the book. So a lot of people are shy away from the courts because they believe that the legal fees can be too cumbersome, and the processes also are not in layman's language that they can really understand. So you find out that it's like putting a square peg in a round hole when you go to the court for all these processes. Now, I'm also concerned about the idea of inducement for judges and justices of the courts. Now, interference also in court processes has been something that I'm sure listeners will also agree, has been something that has been on the front burner also with the judicial system. Interference from the powers that be, especially the reigning government at the time. You find that there's a lot of controversial cases. Let's go back and look at the issue of the value-added tax. Now we see Lagos State government, seconded by River State government, arguing, asserting that the issue of VAT is not in the purview of the federal government. Now we see the Attorney General also on one side saying that the issue of VAT is indeed the federal government's task. So, but then we see that the Constitution must be very clear about who gets what and what gets who. But then interference also from the ruling class it's very worrisome. Also to people out there. Your reactions, please.
Well, on the issue of access to justice, it's a very big issue. It's wider than we think. But you see, we can begin to lay the blames on the issue of access to justice at the feet of each of these players that are involved. Let's take, for example, the government itself. The government has a duty to ensure that people have access to justice. And one of the ways in which the government can do this is by ensuring that the cost of filing papers in courts, the cost of coming to court to lay your grievance at the feet of the judges are not too exorbitant, are not high. And how can the government do this? For example, there was a time when you want to file papers like this, you file with very minimal amount of money, and that was a time when the burden or the financial responsibility of the judiciary is being borne by the government itself. But you see, these days the judiciary itself has been turned partially to a revenue generation outlet of the government. Now you see a marching order that how much is the judiciary itself generating? They should generate money, and the moment you begin to put pressure on the judiciary to become a fund or revenue generating arm of the government, then it will come back to the litigants or those who want to access justice. Because the cost, for example, if you want to swear to an affidavit, probably it was 200 naira before. Now these days you're having to buy special paper, you have to do this, and the judiciary has to do that in order to raise fund to also be able to meet some needs. But if, for example, the government is picking the bill, probably the wage bill or the procedural. For example, you see this argument between the Jusun when they were complaining that the amount that should stand to the credit of the judiciary should be given to the judiciary, so that judiciary will be able to do its own things within its own sphere and time. So you see, this is part of it, because where the judiciary has enough money to cater for its needs, then the pressure will not be on those who want to access courts to get justice. So if the cost is minimal at that level, then the lawyers will also have to reduce his own fee, because the fees of the filing fees will not be that high for him to also access. So we can now from there come to the cost of that of the lawyer too, because when you also look at lawyers, they also charge their professional fees, and lawyers are also living in the society. The exorbitant fees or the exorbitant cost of things that we also find around, we also have a bear on on the lawyers too. So because he also has a wife, he also has children that he also want to take care of, responsibility. So all of these things will pile up to increase the cost of doing things. So I believe it is a cumulative thing. It is something that everybody has to begin to work hand in hand, and then the government has to be alive to its responsibility. There are some areas of the government, for example, this access to justice, education, health, that the government should be funding seriously, and should not expect that it should be a revenue generation avenue for them. So if we are able to take care of this, I believe the issue of reducing the cost of obtaining justice will be greatly reduced. And as touching the aspect of influence, influencing, interference from external
forces,
yes. Well, I would say that each judge knows the nature of his job. And they know that when they are sitting there, they are sitting like the next to God, because they are performing the function of God on that seat. So it's a judge that should not yield himself or herself to such pressure. And that is why when you are occupying such seat, it's an exalted seat that you need to be very, very watchful, to be very careful, especially when it comes to gifts, when it comes to honors, when it comes to things that may be used against you or that may be used to compromise whatever you. They know all this, and I know that they obey it. So, but if you see one or two that are playing along this line, it is because they are doing things that are in conflict with their status as a judge. And we also have some political pressure too, that could be very, very dastardly, especially when you see political matters or those who are in highly exalted political office trying to have influence on a particular matter. The pressure could be so much. I know that the pressure could be so much at times, but then I still believe that those who want to stand their ground can still stand their ground, because we have judges in Nigeria that that maintain their stand, and they are not easily influenced when it comes to their function as a judge on the bench.
Well, the still people on Fresh 106.9 FM, we're talking about judiciary as the last hope of the common man. We'll be right back after this time. Do stay tuned for the second part of the series.